Learn the most empowering hiring techniques. Land the most desirable talent. Launch your company towards massive success. This is the Higher Power Radio Show with your host, Rick Girard.
2 months before the holidays, Nadia, the integrator of a 120-person EOS-run logistics company, sat in a conference room with her leadership team staring at a spreadsheet that screamed what everybody already knew. One manager was tanking the culture, missing targets, and turnover in his team was double the company average. Customer credits were up 31%, and Slack threads smelled like smoke. Now, Nadia did what most nice leaders would do. She delayed. And when she finally pulled the trigger, the manager replied with one simple, 7-letter phrase that actually turned her stomach, which was, "I've spoken to an attorney about retaliation." Only then did she realize the landmines he'd filed in workers' comp claim 2 weeks earlier, taken intermittent leave to care for a parent, and emailed HR a month or so ago before about overtime concerns. No performance file, no documented coaching, no consistent treatment across peers, just vibes and frustration. Now, what followed was 6 months of distraction, legal fees that eclipsed the cost of the salary, and of course, a leadership retrospective that ended in a hard rule. Terminations cannot be surprises, and every decision needs to have evidence that would make sense to a jury of strangers. I'm Rick Girard, and welcome to the Higher Power Radio Show. We help entrepreneurs and executives win the strongest people. We do so by sharing insights from top performing rebel entrepreneurs, business leaders, and game changers like our guest today, Miss Andrea Paris. Now, Andrea is the founder of Andrea Paris Law. Andrea left firm life in 2011 to build a practice around what founders actually need: clear, practical guidance that advances business goals while diffusing risks. She blends her experience representing private and public entities with training in cross-cultural communication and international conflict resolution, giving her a rare lens on high-stakes disputes where people, process, and profit collide. Now, as a business owner herself, Andrea knows issues never live in a legal vacuum. So she starts every engagement with 2 simple questions: what's your goal, and how do we get you there? That's why leaders listen, because her counsel turns complex employment and business conflicts into a step-by-step, growth-minded decision you can defend, which is what makes Andrea the perfect expert for today's topic. Andrea, welcome to the Higher Power Radio Show today.
Thank you for having me, Rick.
It's a pleasure to have you. So I was excited to have you on because it's interesting. I've been getting a rash of reach outs, especially about refill positions. And one company in general, like, is actually starting to refill a position, but like they're going through a similar thing, right? They had somebody who was a low performer, and all of a sudden, like, they're exposed to so many things, right? So let's talk a little bit about why firings are such high exposure, especially like in California right now.
In California, and I think really in the United States general, people really identify with their work and with their jobs. And it's just such a big part of our identities. One of the first questions anybody asks is, what do you do for a living? And so when somebody goes through a termination, especially one that comes as a surprise, it feels like an attack on their identity. And I think also people get very emotional. It's an attack on how they see themselves. Generally, people, if it comes as a surprise, they see themselves as a high performer. And on the employer side, it's extremely expensive. Just defending a lawsuit is expensive. The risk, the exposure you have on the back end is extremely expensive because in California, even if you owe an employee $500, you will not only have to pay your own attorney's fees, but you have to pay the employee's attorney's fees. And those attorney's fees can be in the tens of thousands of dollars. Discrimination cases are usually in the hundreds of thousands of dollars. And it is a distraction from the business owner focusing on the business, because having to pull documents, having to talk to the attorney, it is all a cost on the business itself.
That is okay. So, how do we get ourselves into this trouble?
There's lots of ways that you can get yourself in trouble.
What's the biggest way, though, that you've seen?
What I see is not coaching. Two things. One is how an employee has been treated during the course of the employment. Not coaching, not having documentation, not having clear processes, and the termination coming as a surprise. The second thing is when terminating employees, an employer just goes, well, we have a legitimate reason the person's not performing, and they think that that's enough. And even though California is an at-will state and you can terminate for any reason or for no reason at all, in 2024, law was passed in California that creates a presumption that a termination is wrongful if an employee engaged in any protected activity over the past 90 days. And so there's this 90-day look back period that most employers are not aware of. And so having to look at the employment relationship as a whole, and especially in the last 90 days, is extremely important.
Okay, so what if they've only worked for you for 90 days? Still relevant.
Still relevant.
Okay. But okay, so then what if they've worked for you for 45 days? So you don't have a history of 90 days. If anything's happened in that window, can you get rid of somebody?
Same thing. So before this, 90-day number was put on it, there was a presumption that a termination is wrongful if close in time or retaliatory, if at some point close in time to somebody exercising a right. For example, if somebody complained about their pay, if somebody gave notice that they were pregnant, if somebody went off or filed a workers' comp claim, if it was close in time to when the termination happened, there was a rebuttable presumption that the termination was wrongful. Of course, the employer can provide evidence that no, this was a decision that was made independent of that reason. But now the law has just put this 90-day number on it because it used to be kind of an unclear, what is close in time.
So this essentially gets rid of the whole 90-day probationary period when somebody starts, in a way.
No, as long as somebody did not engage in a protected activity in that period of time, then that doesn't apply. But as a matter of practice, employers should look back and just ask the questions. Did the employee engage in protected activity? And we can definitely discuss what those things might look like in the last 90 days.
So complaints about pay. So like that seems like that might be a common one, right? So they accepted an offer, they started working, and they realized, well, gosh, I should have asked for more money, or maybe they learned somebody else was being paid more, right? Let's just, if that hypothetically happened, and then they went to their boss and said, hey, I'm complaining about my pay, I need to be paid more. Does that start the time clock, essentially?
It depends. And that is the answer. That's the very typical lawyer answer. And I actually should have said my disclaimer at the beginning. I am an attorney, but I'm not your attorney. So take this as just for educational purposes and merely for discussion purposes. The complaint in pay, it depends on what the complaint is. If the complaint is just, hey, you know what? I'm not being paid enough. That may not trigger the 90-day period. But the reason, I mean, it potentially could. So where it could, when somebody just says, hey, I'm not being paid enough, is if somebody complains about not being paid enough and they are terminated, but another employee who just merely complained that, hey, you know what, I should have negotiated for more. If that other employee was of a different gender, is, for example, under 40 years old, but this other person who was terminated was over 40 years old and therefore protected under the Age Discrimination Act, then the terminated employee could argue that, hey, I was treated differently because of my membership in a protected class. So that's one category, right, of a complaint that's just merely a complaint. If the complaint was, I am not paid as much as another employee who does the same job I do, and I believe that it's a complaint about pay equality based on my gender, for example, that would be protected activity because now you're triggering a complaint related to a protected class. If the complaint is, hey, I've been working off the clock and you are not paying me for the time that I worked off the clock, or you are not paying my overtime correctly, or you failed to pay my sick days, any of those pay complaints would also be protected in that 90-day look back period.
Got it. All right, that's a good stipulation, and I'm sure it's case by case, right? So it's not like it's going to be consistent across anyone. And I would imagine as an attorney, you would probably say err on the side of caution.
Always err on the side of caution.
All right, you're listening to the Higher Power Radio Show. I'm your host, Rick Girard, and for our podcast listeners, we're going to take a quick educational moment from our sponsors. All right, I'm digging in deeper with our guest, Andrea Paris. Andrea is an employment attorney. She's a damn good one, by the way, and she's the founder of Andrea Paris Law. So we're talking a little bit about the 90-day termination window, and essentially, what you need to be aware of as a business owner so that you don't get yourself into trouble or you don't get yourself sued. So, all right, let's talk a little about what we need to do to solve this problem. What, me as an entrepreneur, as I'm hiring people, like, what do I need to put in place to protect myself? Like, what steps do I need to take to not get myself into trouble, especially since I get myself into trouble a lot?
Don't say that, Rick.
I'm totally kidding, by the way.
The no surprise termination policy it's a wonderful way to put it. And whenever I give presentations or I strategize or consult with my clients, I always say, don't let the termination be a surprise. And it's because I get calls from employees all the time. And the number one reason that anybody goes looking for an attorney, and if an employee goes, you want the employee not to go looking for an attorney to begin with, because somebody will take the case. And even if it's not a strong case, having to deal with it will be very expensive for you. And what drives an employee to look for an attorney is when the termination comes as a surprise. I hear it all the time. I was never given any warnings. I was never disciplined. I did not receive any write-ups. And all of a sudden I was just terminated. And so having a conversation cadence is extremely important. Coach early on, document performance discussions, whether it's formally as a write-up or acknowledgement that, this was the discussion that we had, or even if it's just a confirmation email, have some kind of documentation of the discussion that was had, identify what the issues are, how an employee can remedy the issues, and also a timeline that you expect an employee to remedy the performance issues.
God, you know what? This isn't this just a leadership. This is really a leadership issue. Like, be a good leader and have conversations with your people because, you know, I this is kind of striking a recent conversation that I had with somebody where um, they were talking about how they need to get rid of somebody, and it was all coming from one person who was a manager who was after like we really got into the conversation, we figured out that that manager is kind of their internal arsonist, right? Like this manager is the problem, yet the manager was kind of trying to push other people out of the way, um, and could probably create a lot of these scenarios for the business, right? So, um, okay, so I just went off on like a totally sorry, it just sparked something else. All right, so conversation cadence. I mean, so like make it a policy within your managers and everybody to make sure that they document and have conversation with their people.
Yes. And you bring up a really good point about it being a management issue. Because the value that I see in coaching or having conversations with employees is not only does it protect you or give you evidence to defend yourself if there ever is a claim, but it also helps you get the most out of the people that you spend time, money, and resources to hire.
Yeah,
And so if you have taken the time and made the effort to hire this person, you want them to succeed. You want to be able to get them up to speed or get them where you want them to be. And without communicating those expectations, sometimes employees don't get there. And having those conversations is just a continuation of the investment that you've already made in the employee.
gotcha. So talk to me about like how things should be documented.
There are multiple ways. So, like I mentioned, you can either have a written recap of, hey, just want to confirm that here's what we discussed. This is what we agreed to. This is the timeline for you to remedy these issues. And let's set up a date for a follow up or a check in. If it's an ongoing issue, and for example, if you've already, and this is also an important point, is if you've already coached somebody on something and now you are moving to, a second coaching, a second warning, maybe a formal write-up, reference all the other coachings that you've had, reference the other conversations that you've had, um, identify the issues that continue after the coaching. So this way, there is a trail of coaching and conversations that have, that shows that this is an ongoing issue versus, oh, you know what, this happened in the last 90 days and this person was terminated or, something along those lines. You can say this is an ongoing issue and we've tried to work with you and it has, you haven't remedied it. Definitely do follow-ups, have a final performance, have a performance improvement plan if that is your practice. But most importantly, make sure that you are treating people who are similarly situated in the same way. So if a type of conduct, for example, excessive absences, I see this a lot. What do you consider an excessive absence? And if it's somebody's 5 minutes late consistently every day in the week, if you have one employee who does that consistently and does not get any coaching, does not get any write-ups, yet another employee is getting coached and getting written up, then that employee could potentially have a claim that, hey, you know what, I am being treated differently and it's because of whatever protected class that they can come up with.
So you just don't want to give people the excuse. Look, everybody needs to be treated the same way, same policy for everybody. If it's your cousin who works for the business, you still got to write him up and have conversation, and there's no favoritism.
Yes. And that's, again, just a lot of this is just good management. Not
Yeah.
only are you helping your attorney be able to defend you if there's ever a claim, but it is also just good management because you don't want to create resentment within the organization when people feel like they're being treated differently and other people, are getting favorable treatment.
Yeah. All right. So talk to me about this 90-day look back audit. Like before they terminate, like what should they go through? Is there like a checklist maybe or something that people should be aware of?
You can create your own checklist. I have a checklist. If anybody wants a copy of my checklist, I am happy to share it. So just, reach out to me. I'd be happy to share that. What generally is looking back in the last 90 days, have they made any claims, whether it's a workers' compensation claim? Did they file a PAGA claim with the LWDA in California?
What is PAGA?
PAGA is it's short for the Private Attorney General Act, and it allows employees to enforce employment law violations in the shoes of the state. So they can seek penalties on behalf of themselves and other employees. It's like a class action light, but for penalties.
And so like if they file something like that, are you notified right away?
You will generally get notice from an attorney, usually from their attorney. So, or the LWD might send you a copy of the complaint, but if you have awareness of any claim or complaint that was filed, that an employee filed against you, an employee can even sue you while they're employed with you. So if they engage in any of that type of filing of a claim of any type, that is protected activity. If, for example, if I would also look back to see if an employee took any time off, it took any leave, whether it's sick for their own illness, for the illness of a family member, for example. So any of these leaves, I would be aware of that. If an employee gave you notice that they are pregnant, if an employee gave you notice that they need accommodations, for example, for a mental or a physical disability, if they gave you doctor's notes saying, I'm working with a doctor, I need to shift my schedule to part-time, or whatever accommodations an employee might need, even a religious accommodation, or if an employee just made any claim of discrimination, harassment in the workplace, complained about their boss or another employee, any of these things would be considered protected activity that would create the rebuttable presumption that the termination is in retaliation for engaging in any of this activity. Again, it's rebuttable. So if you have really good documentation showing that, that this decision had been in the background or in the works for a while, then you can overcome that presumption. And again, I would say, sure, the law says it's a 90-day look back, but if this happened on day, 91 days ago, I would still be careful. If there was anything that happened close in time to the termination, just make sure that you have your ducks in a row before you terminate that employee.
Well, and I feel like, if you're having conversations with people and they're having look, life happens, right? I would imagine that, like, let's say you have somebody in the case of the story that I told in the very beginning, right? They had to get rid of one of their managers. The problem is that they actually didn't have any conversation, right? And no documentation, no anything. And I would imagine, like, since this person was going through life and having some challenges, maybe they would have taken a step back from their management duties and into like a more individual contributor role, or like maybe sidestepped or gone into a different area to where they could have been effective if only they had a conversation.
Yes. And I would caution on the conversation, and you bring up a good point about changing somebody's roles,
Yeah.
because the 90-day look back law applies, and really any California law related to retaliation or discrimination talks, the trigger point is not just termination, but any adverse employment action. So an
Mm.
adverse employment action could be the failure to promote. It could be the failure to provide training. It could be demotions. So any of these things that will affect, even taking reports away from somebody, any of these things that affects somebody's pay or authority, will be considered an adverse employment action. So it's not
Ooh.
just terminations, although we've been discussing the context of termination as the trigger point. There are other trigger points, and that's just any adverse employment action.
I would imagine, like, I know that in the past, a lot of attorneys that I've talked to have cautioned about like having video conversations, like having recordings of things, right? I'm of the belief that actually, as long as you're doing these things and you're having these conversations, it can only benefit you. I mean, like having the benefit of a recorded conversation would most likely help, right? But also, then you don't have the he said, she said thing that goes back and forth. But then again, if you do something stupid, it's gonna bite you, right? So don't be stupid.
Yeah, the video recording really does cut both ways.
Yeah.
But you are, if you have your ducks in a row and you have good advice and you treat people well, it could really help you.
Yeah.
I told you that I had one of the, just a gift to me was a video recording of a meeting because the claim, the former employee sent a demand letter and referenced this one very specific meeting as the meeting where a whole bunch of things were said that would support their case for potential wrongful termination. And we pulled the recording of that meeting, and none of that was said. And so that was a gift that is extremely rare in my area of practice.
See, but that, it does avoid the he said, she said thing. And, look at it, you're always gonna err on the side of the employee. Because I mean, look, I mean, I don't think anybody wants to terminate people, and I think that they all want to have people be great employees. But again, things don't breakups are never fun, right?
Right. And
All
it
right.
is
So on the day of termination, like what do you do and what shouldn't you do?
number one rule is treat people with respect.
Yeah.
I always think back to, I think Malcolm Gladwell wrote in Blink about how people don't sue, the doctors that have good bedside manner are rarely the ones that get sued, and it's the ones that have bad bedside manner who get sued. And I see that in my practice all the time. And when people feel like they're not being treated with respect. So have more than one person in the room when you are terminating someone. That's my advice. Have somebody sit there and take notes, treat the person with respect. Again, make sure that it was not a surprise that the person is being terminated. If there were policy violations, I would reference the policies that were violated, and make sure that you have all the things ready. In California, you have to have various notices that you give to employees, and then also make sure that their final paycheck is available upon termination. So make sure that all those documents are available for the employee at the time of the termination.
What shouldn't you do?
Well, don't let it come as a surprise. Don't, and this might be counterintuitive because the company is thinking, well, we will escort the employee out, make sure they don't steal anything. But that is one of the things that gets people the most. I hear it all the time that they felt demeaned by being escorted to their desk to clear out their stuff in front of all of their colleagues, everybody, and it is extremely embarrassing. And that is what will drive somebody to call an employment attorney.
I totally get that. All right, shoot. Well, we're just about out of time. Give me two or three key takeaways you can give the audience that they can plug into the business today.
Number one, get your policies in order, train your people well. Second is document everything. And the last thing is just treat similarly situated people the same way and treat people with respect.
Yep. Oh, Andrea, thanks so much for your time investment today. And I want to welcome you to the Higher Power Radio community. Now, what's the best way in which members of the audience can find you, find your firm?
Sure. My website is andreaparislaw.com. You can schedule calls, book appointments, anything there. I'm also on Instagram as Women at Work Lawyer.
I love it. All right. Well, I want to thank you for tuning in this week's episode of Higher Power Radio. A quick thanks to our team, Brian Colburn, Andrea Ballin, and Rick Girard. If you're listening to the podcast, please subscribe, review, and share. After all, this show's for you, and we want to continue to bring you valuable content week after week. You can check us out further at Hire, H-I-R-E, Power, P-O-W-E-R, Radio, R-A-D-I-O.com, or you can drop me an email at rick@intertrue, just like it's spelled, there's no E at the end of it, .ai. I'm your host, Rick Girard, and you have been listening to the Higher Power Radio Show. Aloha.
Thank you for listening to Higher Power Radio.
Catch our LinkedIn Live show every Tuesday at noon or download the podcast on iHeartRadio, iTunes, YouTube,
Or your favorite podcast platform.
We appreciate you joining us on Higher Power Radio with your guide to hiring success, Rick Girard.